special hearing is being conducted via Zoom, and on my knowledge of Ms. Adams, I see her picture in a small video frame, and Ms. Adams is attending this, and also Justin Collier, who is the attorney for the petitioner, Mr. Duncan, is attending. And Mr. Collier, can you hear what I am saying right now?
I can. I'm on my cell phone though, so I have to have my phone right here, so I can't really put on the camera, but I can hear you just fine.
All right, that's fine, Mr. Collier. Just wanted to make sure.
Yeah, thank you very much.
Mr. Collier, it's my understanding we are here right now, Mr. Collier and Ms. Adams, on motions by Ms. Adams. One is for adequate cause for a major modification of a parenting plan. The second is contempt of court. And the third is an objection to relocation of the children from Okanogan County over to Skagit County.
Correct. My only concern, and I guess a question, frankly, for the court is, this is probably about the fifth time she filed a motion for contempt, but not had an order to show cause signed on the contempt. And so I don't know if the court is willing to hear it or not. In the past, it's been my practice, and I think courts have been requiring an order to show cause. And we've been through this numerous times, and there's still not an order to show cause. So I don't really understand why she doesn't take that step. But whatever the court wants to do, I'll make my argument for whatever the court wants to hear, frankly.
All right. So, Mr. Collier, at this point, since Ms. Adams is the moving party, I'm going to hear from her first. Ms. Adams, you can go ahead and you can unmute and please tell the court why you're here. And if you want, we can start off with the adequate cause for a major modification of the parenting plan.
Okay. Good morning, Your Honor. July 8th, 2018 is the last visitation that I exercised with my daughter due to the presence of my ex-husband who didn't need to be there. And I petitioned the courts, and Judge Hotchkiss wanted to hear from D. Cummings. So D. Cummings wrote a letter dated September 11th and filed with the court, and it concerns some behaviors that were addressed during the interview with the parents, and her recommendation at the end was that the child see a behavioral health and that I not see her again until that happened and that it resumed supervised. So during the beginning of this hearing that I've been waiting for today, I have contacted D. Cummings. I have working on transcribing and notarizing that document. And she is stating that there's nothing she can do and that I just need to go through the proper procedure and try and come to some agreement with the father and the attorney on how to go from here. She's not taking clients, but she would not set me up with visitation. And the visitation was not followed January 29th, 2019, when Hotchkiss ordered that, because they've never been cooperative with any other form of visitation agent. So outside of D, I've only seen one other person, and that would have been July 10th and July 24th of 2016, I believe. So since the custody has changed, we're 6 years in, and for the last 3, I haven't seen her. I'm not finding any behavioral health records, nor to my knowledge have any been produced for the court, which was ordered on the 17th of March of this year by Commissioner Safar. They did, however, take her to a doctor and a dentist in April, And I feel that had I not been a little loud about this, that wouldn't have occurred due to records. I'm glad to hear that she's doing okay, no cavities, and that she is doing okay as far as physically. However, she's in the second and third percentile for height and weight, and she's 50 pounds and almost 10. I'm not sure if I should be concerned about that, but my concern was that she hasn't seen behavioral health, and she hasn't been timely with her heart specialist. She was 2 years late on her follow-up, and she hasn't seen any doctor until I made a big deal about it, which I make a deal about it because I'm still her mom, and I do what I can from the position I've been put in by the courts, and I've been wearing this for a while. So I understand maybe some of the procedure of it more than before, but I do believe that this needs some oversight. I can't just be paying $50 an hour to see her and afford to live. I did just graduate my daughter, so, you know, we're doing what we are doing and living every day on this farm and working this piece of property and stewarding it and trying to keep up on it, and with fire season and just all the things going on, and dealing with court. My stress levels and blood pressure have been high, but I'm not here to complain. I just need some form of resolve, and the court is my only appropriate means to do so, so I appreciate you hearing me today. Those are my main concerns, and I would obviously ask that we do something today to start repairing that bond with her and I. The situation has gotten slightly convoluted, to say the least, and we need to just kind of pick it apart and see what's going on. I don't know that that was really done in the first place. I think maybe some rash decisions were made on all parts by all parties. And I have since tried to communicate with the father recently, which he gave me permission to record. But it took me almost a day just to get through the first 14 minutes, and I think that that's enough. It goes on for another 45, where he basically refuses to cooperate unless I lift the original allegations. And I know that there was also disclosure from my daughter. I'm not trying to bring that up to cut my foot off today. It's just that it is part of the file, and it is part of how we got here, so it does need to be looked at in some form as to how we could have possibly gotten here today. And let's see what we can do to get my daughter and I back into a situation where we're in a healthy environment. I can promise that I'm in a healthy environment. You know, what I'm hearing from the other party, besides no response outside of a very late intent to relocate, where originally I was told they were just out of town, but the officer confirmed that the house was vacant. So I had no idea where she was, and trying to deal with that while dealing with graduation requirements for my daughter and keeping my home peaceful. I kind of knew heads up that he was moving back over for that other job because I know that he never stopped working there. And outside of that, I don't have a window into that life at all, besides my 15-minute phone calls with her, which he has dictated every single one.
Ms. Adams, can you now address why you're wanting Mr. Duncan to be held in contempt?
I feel very strongly that he's playing a huge role in not being able to see her because there's been no cooperation. The court, if the court adopts Dee's recommendation that my daughter sees some form of behavioral health before we resume these visits, then he needed to have done that. It's stopping me from being able to move forward in any way without courts, and then it's just been drug out.
The decision made by Court Commissioner Safar.
Say that one more time.
There was to be a mental health evaluation of the children.
Are you asking if he said that?
Yes, is that what you're relying? Is that Commissioner Safar decision you're referring to?
Commissioner Safar on the March 17th calendar the hearing reflects that he asked for 30 days to produce medical records. He didn't specify behavioral health, but the behavioral health was specified in the recommendation by D. Cummings on September 11th of 2018. If the court adopts that letter and is following her recommendation, then she stands with that letter. That's what she's stating today.
And is that the letter that was filed, I believe, in October of 2018?
Yes, that would have been filed by Justin Collier around the same time that I was getting an attorney due to some of the contents of that letter.
So my understanding is that you are asking that Mr. Duncan be held in contempt because he has failed to cooperate or facilitate your visitation with your dog.
Yes.
Now, the third matter that's brought before the court was an objection to the relocation. I think I misspoke. I believe that they actually moved back to Island County. Is that correct?
No, they moved to Arlington, which would be in Snohomish County, I believe.
And the basis for your objection? I understand that you're stating that notice was not timely. But other than the fact that the notice was not timely, what is your objection to the move?
Well, let's just say that I kind of felt when they moved back in the first place that a mountain had been moved and we would have a better opportunity to see each other because we were only a 2-hour drive away, no passes, no closures, road closures, etc. And in that year, nothing has come of that. So now that they've moved back, I feel like we're going to be back to the same old thing. Undue traveling for her, undue expenses if I were to travel there. And I think that she needs to come and repair life here as well. I'm not trying to take her away from that one. I know she's bonded with everyone. But I object to them moving like that and causing that undue stress and lying to their attorney and thus lying to me through their attorney by proxy and just unnecessary worry about where they went due to the underlying situation that I won't give up in this case and the lack of oversight with doctors, dentists, special heart therapists, behavioral health, just kind of overall kind of points to me, and I don't get to color this with emotion. I understand that. But it points to me in a direction of why is she not, she just needs to be seen. She's in the 2nd and 3rd percentile, 50 pounds, 10 years old, and some of the behavior of the father is definitely creating an environment that's undue, and there's no oversight here. So I object to the relocation because I object to the relocation because I have no educational decision-making, and she's homeschooled. I have no medical decision-making, and she's not getting proper medical. I'm not getting to see her, and I know that that's psychologically proven it's not a good thing. It causes problems later on, I know, and their defense is that I'm crazy or that I'm not seeing her. I did a mental health evaluation with Catholic Charities more than one time. The most recent one was filed right around the same time as that letter from D. Cummings, and it states that I have post-traumatic stress disorder due to DV spousal abuse with my ex-husband. That was my diagnosis. They're ignoring that fact, and a lot of these predicaments that the way this parenting plan sits today, the way that it's reading, it's just there's so much holes in it, and it's so broad. I don't necessarily want to tighten it so much as lift the supervision requirement and be able to have some kind of oversight so that we're not just going back into that old pattern of behavior because I've had no way to show otherwise besides to stop seeing her in order to gray rock him, and that's not fair to her or I. So I object to the relocation because it's just further custodial interference. It's further, like, why couldn't they just say it like adults? There's a lot of times where they can't just be upfront and honest about things.
Ms. Adams, I have one question, and that is, the last proposed parenting plan that I see that you filed was filed, a couple of years ago, but it's still out there. And what it did was it removed limits on you also being a decision maker, and it eliminated supervision. It had alternating weekends, alternating weeks in the summer, half of the spring break, alternate Thanksgivings and Christmas breaks. Is that the parenting plan that is the one that you're referring to when you say you want to make a change in the parenting plan?
I think that would be the most reasonable parenting plan to start with, just to kind of level the board. I would go for the other one in the other case in Douglas County, but maybe I should be realistic and say only if things continue the same way and they don't resolve. And I don't want her in the middle of conflict, so I would definitely lean towards your discretion in that area as to what you think would be best. I think not like all at once, but definitely something normal, and see if we can behave and not at her expense.
Ms. Adams, is there anything else before Mr. Collier has an opportunity to address these issues?
Only the fact that I haven't really had him address any of these issues. And, I want him to I'd like to make sure that he's getting the best information from his client also before he responds to me. And then also I want him to not badger my character if possible, because he needs to look at that Catholic Charities record before he keeps bringing up my mental health. And I'm not just not seeing her because I don't want to see her. That's ridiculous. And I think a lot of those behaviors in D. Cummings' letter are not because of me. It's because of this whole thing. I don't know what part, but I just want to, those things and her medical, like right now, I mean, maybe it's not too abnormal that she's in the 2nd or 3rd percentile, but I'd like him to explain some of that. And then, yes, other than that, no, I have nothing else, besides if I have something to add after he's spoken.
Mr. Collier, this is your response, please.
Thank you. I'll try to be brief because I think I have been in this case like 5 or 6 years, and frankly, Your Honor, and I see Ms. Adams in a way, but realistically, she could have had visits this entire time. I mean, I don't know what she's talking about. That she talked to D. Cummings briefly, and it's not filed, but I've talked to D. numerous times, and Darcy's entitled to her supervised visits, and she just won't do it. And when she had the visits, there was not one visit in my memory that Mr. Duncan did not bring the child, drive his house for the visit, because he's always lived outside of the Wenatchee Valley area, and then waited and picked the child up from the visit. And she just, I don't really understand her thought process as to not doing the visits, because I do think it's probably detrimental to their child. But she hasn't, and we can't control that. And some brief backstory is Judge Hodges, she had custody, and Judge Hodges bent over backwards listening to her just consistent and repeated statements that Mr. Duncan had sexually abused her child. I mean, to the point where there was a GAL appointed at public expense, there was doctors and nurses spoken to, numerous CPS investigators involved, and to this day, even though every bit of evidence shows that he didn't, as we sit here and make this argument today, she's still convinced that he did. And to the point to where she lost custody of her child and moved to supervised visits and everything, and she adequate cause motion. But really the only thing that's really ever changing in these certain situations is that she's going further and further without seeing her, because if she wants to see her, she can see her next weekend or the weekend after, whenever she can start to visit. She can see her right away. She only pays $50 a month child support, which I know, I mean, that's fine. My client's not complaining about that, but it should then allow her to have some money for the supervised visit. And I guess I don't understand that process, nor do I feel that my client, Mr. Duncan, can be held in contempt for it. There's not a court order that behavioral health be completed. I think it was in one of the letters becoming in the past. There's been so many letters, frankly, from Ms. Cummings in the past. And there's no visits that were missed. There's nothing that he can be held in contempt for, in my mind. And some of the visit behaviors, and I know Ms. Adams disagrees with Ms. Cummings, but I mean, some of the things that are present in those letters that Ms. Adams thinks happen, Ms. Cummings doesn't. And you know, that's a danger in this case. So I don't think the court can find an adequate cause. I think the court already ruled on it 3 months ago on the same exact thing. I don't think the court can find contempt. I do agree my client should have given advance notice of his move. And I've reiterated that to him. If he's moving, he has to give notice. And I think, you know, ignorance isn't an excuse, but his thought was, well, she has supervised visits. I can do those from wherever. It doesn't affect anything with her visits or her phone calls. I'll still allow those to occur. So he wasn't really thinking clear, and he needed to get out of the house, and he needed to get a new place to live for his job, and etc. But I gave her notice of where he's at as soon as I got it. I'm agreeing it's not timely. I'm agreeing he should have had advance notice. But he's complied with what Commissioner Safar asked, which was to file the current medical and dental records. There's nothing that shows that there's concern from a doctor or dentist about neglect or anything like those lines. Yes, records here from Mr. Duncan. I mean, there's frankly nothing, Your Honor. And to me, it's just unfortunate. I wish she would start her visit again, and I think Ms. Cummings, from every time I've ever talked to her about it, would do it, and she could have some supervised visits. But really, until she is willing to, you know, not make CPS referrals and not question the child and not video the child about, you know, inappropriate touching and all these things, I think it's really going to be impossible for her to have unsupervised visits, frankly. And that's what the court's ruled in the past. So I don't know if the court wants me to go any deeper into it. I don't think I need to, because I don't think there's a basis for the modification or for the contempt. And I agree that the notice of relocation was late, but when you look at the factors, it doesn't change anything for Ms. Adams. Again, my client will comply with the visit, he'll comply with the parenting plan. And in fact, I would hope it should make it easier for Ms. Adams to deal with, because now my client is home with the child on a nightly basis from work versus having to commute. So really, I think it's a better rule for the family, but again, the notice is late. So we'll deal with that, however the court wants to deal with that, but I've already talked to my client about that. And really, that's all I have to say, Your Honor.
Thank you. Ms. Adams, is there anything you want to respond to?
Just give me 1 second. Well, the first thing I've starred here says I can notarize the conversation that I just had with Dee. I transcribed it myself, but it was a recorded telephone call. And then if she does state that I need to get a new current order before she's going to resume anything. I highly do not recommend that based on what I have submitted over and over and over again, because those behaviors were not addressed, and it was inappropriate and unprofessional of her, and I'm not trying to speak ill, or I'm not also trying to apologize, that he could have just simply not been present when I arrived and left. That never happened. I'm paying that much money, and we can't even go to the taco truck next to Neil's Boots. We can't fly a kite. We can't even go outside. We're in a cubicle. For $50 an hour at 12 hours a month, that's $7,200 a year. I can't maintain my vehicle half the time because I have older vehicles. I'm not complaining either. My daughter is not a number. And I do, again, apologize for cutting my foot off here, but I'm smelling racket. So I will not be able to comply with continuing visitations with Dee. I have tried, like a mama would try, to find anyone else that they would be happy with at the same price or reduced. I want out from underneath those limitations altogether. Based on the records, which Dee agrees, I had some issues with kind of some of my physiological responses to him being present 15 minutes into and 15 minutes before it ended and started. There was times where he didn't need to be there. There was times where he had his Genesis parked in the parking lot playing our wedding song on repeat while the 10 minutes into the visit, and Dee is denying that that happened and there should be a police report. I'm done with being harassed, provoked, and intimidated. I have a right as a witness. I even have a right to believe the allegations I brought to this court in the first place. I understand the need to let that go and let the course take its course. I understand there was no evidence or hearsay hearing. So if any of those issues were to come up in the future, they can be addressed then. I'm willing to let all of that go for now because, quite honestly, my daughter is not psychologically plastic anymore. She's prepubescent now. I would like to definitely adopt at least that parenting plan where it was fair across the board and maybe get some make-up time with her. But I can notarize the conversation with Dee if I need to.